Good afternoon and welcome to the latest webinar in our week-long Welsh Planner Live series organised by RTPI Cymru. I'm Roisin Wilmot, I'm the Director for Wales and Northern Ireland with the RTPI. So this afternoon we have a legal view looking at the role and relevance of climate change on planning in Wales, particularly given that planning is a quasi-legal function. I'd like to thank our sponsors, Francis Taylor Building and Savills. And if you're tweeting this afternoon, please use the hashtag WalesPlanLive2020. I'm very pleased to say that we are joined by two barristers today, both from Francis Taylor Building. We have Annabel Graham-Paul. Annabel has particular experience of Welsh devolved public law and the planning system in Wales and has acted for many clients across the public and private sectors. She's also a councillor of Llandovery Town Council and was mayor for 2018-19. And we are joined also by Emyr Jones. Emyr was called to the bar in 1999 and practised in Cardiff until joining Francis Taylor Building in 2018. He's appointed to the Welsh Government's panel in 2013 and has a thorough knowledge of Welsh planning law and policy, and is the current editor of the Wales section of the Green Book. We will hear from Emyr and Annabel this afternoon, and then we will open it up for questions. Please do send in your questions using the chat function, which you can see in front of you, and we'll get through as many of those as we can. So firstly, if I could turn to Emyr. Thank you.
Can I check, Adam, if you can hear me and see me now?
Yeah, you're good to
there
go.
Are.
Continue.
There are. Apologies to everyone who just looking at me as though I was in a Charlie Chaplin movie without the comedy. What I said is that I'll talk about a recent Welsh Government consultation on coal policy and discuss two cases to do with fossil fuel extraction, both cases based in England, but they have some relevance to the recent Welsh coal policy. And then Annabel will talk about 4 or 5 cases dealing with various aspects of climate change. So I'll start with fossil fuel extraction policy and move on to the first slide. The Coal Policy in Wales document is a consultation document issued on the 1st of July, and the responses were due in yesterday. This is a standalone coal policy, and most of you will know that there's already planning policy, national planning policy about coal in PPW 10, and I give the reference there to chapter 510. And in essence, the national policy in terms of planning is that proposals for mining are not permitted unless the applicant can show wholly exceptional circumstances. So why is there a need for a standalone coal policy given that there's already national planning policy relating to coal extraction? Now, the reason for that it really comes from the Coal Industry Act 1994. The Coal Industry Act 1994 established the Coal Authority, and the Coal Authority really is a successor to the National Coal Board. So it's part and parcel of the privatisation of the coal industry. So the Coal Authority assumed the assets of the National Coal Board, so all unworked coal in the UK vests in the Coal Authority. So a coal operator, if it wants to extract coal, must get a licence from the Coal Authority and also a lease in respect of the unworked coal. Now, licences are granted on the basis of the operator having suitable expertise. The operator has to show that it has financial standing, so that, for example, if there's subsidence and homeowners need to be compensated, that they're good for the compensation, matters of that nature. At the top of the slide, my first bullet point, I've referenced Section 2. Section 2 sets out the duties of the Coal Authority, and I've identified one of those, or one element of that overarching duty, and it's a duty to develop an economically viable coal mining industry in the UK. And we need to bear in mind the age of this legislation. It's 1994. Climate change, I think, was a known phenomenon, but it wasn't as high up on the political agenda, and less was known about it scientifically than the position now. So part of the Coal Authority's duty is to promote coal mining as an industry. What is the relevance of the Coal Industry Act, however, to Welsh Government and to Welsh Government policy? And the explanation for that is given on this slide. It's the Section 26A of the Coal Industry Act, which was inserted by the Wales Act 2017, which provides, if or to the extent that a licence under this part authorises coal mining operations in relation to coal in Wales, it shall have effect only if the Welsh ministers notify the authority that they approve the authorisation. As I said, the Coal Authority will look at the expertise of an operator. It will look at financial standing of the operator, but the terms and conditions are pretty detailed. None of that will be effective in Wales unless Welsh ministers approve the authorisation. Now you'll see from when we look at the coal policy that Welsh ministers are not particularly interested in or have the expertise to judge whether an individual operator has the financial standing, whether the individual operator is sufficiently experienced in coaling, and they're not really interested in matters of health and safety. But clearly, we've looked at PPW 10. There is a climate change policy which is effectively hostile to coaling. So the policy says in the overview, in terms of the need for Welsh policy, the devolution of powers on petroleum extraction and authorisation of licences for coal mining establish the need for Welsh policy on fossil fuels. There is already a petroleum policy, which is effectively no fracking and no new petroleum licensing, and that was announced in December 2018. But that petroleum policy is to do with petroleum, not with coal, and therefore there's a policy lacuna, if you like, which is why coal policy is required because of Section 26A. Welsh Government needs a policy as to the basis on which it will approve or not approve of a coaling licence. In terms of the content of the coal policy, it really reflects, unsurprisingly, PPW 10, but the policy objective is to avoid continued extraction and consumption of fossil fuels. There's also a policy imperative to have a just transition. So the move away from coal must be achieved in ways that preserve and, where possible, increase prosperity. Of course, all of this reflects some of the goals in the Wellbeing of Future Generations Act. So you need there's a goal to have a prosperous Wales, but also one which is environmentally responsible and tackles climate change and so on and so forth. So you've got those two goals reflected on this slide, and in the policy aspirations or objects of Welsh Government. Perhaps I'll just say, in terms of a just transition, there are statements in the policy talking about the encouragement of innovation. So, for example, in steel and cement, coal is used to provide the energy. Welsh Government is encouraging innovation so that is no longer required, so that there are low carbon alternatives to coal to allow those industries to carry on in a way which is better for climate change and tackling climate change. The policy refers to a report, a Wardell-Armstrong report, which came out in September 19. It's a reasonably detailed report, about 60-70 pages, and what I've done is to highlight some of the evidential findings from that report. So they say coal imports will increase in the future, that the UK and Wales is already a net importer of coal, and that is going to increase essentially because there's still domestic demand and domestic production of coal is falling. The shortfall will come from Russia, or predominantly from Russia, America, Australia and Colombia, and they point out that 25% of coal producers traded internationally. Now the flip side of that is that most coal is consumed in the home country. In terms of Welsh consumption of coal, the report talks about heritage railway and coal used in domestic homes, but that really is pretty small beer. The main Welsh consumption with the closure of Aberthaw power station is steel and cement. And Port Talbot, the Tata Works there, I think the reference was for 2017, 20% of Welsh greenhouse gas emissions can be attributed to Port Talbot Steelworks. The continued manufacturing of steel depends on future supply of coking coals. So I've already referred to Welsh Government having a policy to encourage innovation, and Wardell-Armstrong report acknowledges that, but the innovation, obviously it's inherently unpredictable how quickly that would come on stream or whether it would, but they say it's not going to happen in the next 3 or 4 years. And the same applies for Aberthaw cement works. That is reliant on coal, and it'll be imported coal if it's not domestic Welsh or UK coal. In terms of the limitations of that report and its recommendations, there are two main points. The first is that they did not assess whether new extraction of fossil fuels in Wales would add to rather than displace existing production elsewhere. So to perhaps put that in concrete terms, if we assume that all imported coal that comes to Wales comes from Australia, and there's Welsh production of coal which displaces that, would all the Australian coal be dug up anyway and consumed elsewhere? Would some of it continue to be dug up and consumed, or would none of it be dug up and consumed? And whether it's 1, 2 or 3 obviously has big climate change implications, because if you dig coal in Wales and that means that coal in Australia stays in the ground, because you're avoiding emissions to do with transportation of the fuel, then that is a good thing for climate change. Wardell-Armstrong said, well, Armstrong's report says, we don't have that information and we've not assessed it, and it's very complicated. But the recommendation is that to Welsh Government, you should study the impact of indigenous versus imported coal in terms of the net impact on climate change. So that's the recommendation in terms of this issue about indigenous versus imported coal. The policy document says that they are considering, the Welsh Government are considering Wardle Armstrong's recommendation re further evidence, and one of the questions in the consultation document is, do you know of any evidence which would help us have a better view or more refined view on this indigenous versus imported coal point? And the policy says that there's existing evidence which recognises that domestically produced coal will have lower embedded CO2 emissions due to lower freight emissions. So that's the argument which has been run at inquiries in England to do with fossil fuel extraction. So that's acknowledged, but then you have the but, and this is really the Welsh Government's policy or provisional policy, subject to evidence from this consultation, which is that Welsh ministers consider that domestically produced coal used within Wales does not automatically result in a net positive global climate change impact, as the coal which would have been imported into Wales will likely be consumed elsewhere. If the displaced coal is indeed consumed elsewhere, Welsh coal then becomes an additional source of global greenhouse gas emissions. So that's coming back to the point about if the Australian coal is going to be dug up anyway, even though it doesn't come to Wales and is burnt, then the Welsh coal is simply added to aggregate production, aggregate consumption and aggregate greenhouse gas emissions. So some reflections on the policy document. First point is that it's consistent with PPW. It's basically hostile to mining in Wales, or coal mining in Wales. It takes a global perspective with regards to emissions, because as shown on the earlier slides, if you simply focus on emissions from burning coal, I don't know, at Port Talbot Steelworks, they are likely to be lower if that coal has come from Wales, from a purely Welsh territorial perspective. But the question is, will they be burnt in Colombia, Australia, America and Russia? That is a contrast with the way the Climate Change Act 2008 is structured, and that's reflected in the Environment Wales Act 2016, because the emissions which are targeted and budgeted are predominantly territorial. There are some exceptions, such as air travel, but it's basically territorial production of emissions as opposed to consumption of emissions. There's a request for evidence. You know, do you have members of the public or those interested in this consultation evidence about this indigenous versus imported coal? If that evidence came forward and it was accepted by Welsh Government, really they should be changing PPW. Would that happen? Second bullet point is that total emissions from coal extraction is a product really of aggregate global extraction and freight emissions, and it's empirically very complicated. So going back to my very simplistic Australian example, if the Australian displaced coal stays in the ground, then we should be digging Welsh coal. If it is all dug up, then we shouldn't be digging Welsh coal. If it's somewhere in the middle, then you've got to balance the total amount of extraction against the emissions from transporting coal halfway around the world. And that's clearly, conceptually it's quite straightforward, but empirically it's extremely complicated. Welsh Government in this policy has a clear policy, which is don't extract Welsh coal, and that means that inspectors are not faced with complicated global questions unsuited to an inquiry process. The final point I'd make on this is that if you go to Section 2 of the Coal Industry Act, the Coal Authority has a duty to promote coal mining, and obviously that's at odds with Welsh Government policy objectives. So you can see the coal authority might say here to a coal operator, here's your lease and here's your licence, go away, we think you're safe and responsible, and extract some coal, but is that licence going to be approved given that Welsh Government, for climate change reasons, is against coaling? I'll just finish off looking at two cases identified on this slide. So Preston New Road Action Group, that's a shale gas or a fracking case, and HJ Banks is an open cast mining case. I'll just go quickly through Preston New Road and the facts. It was an application for planning permission to conduct exploratory works as to the feasibility and viability of fracking. The local authority refused permission. The Secretary of State granted permission on appeal, and then various action groups brought Section 288 challenges. The first appeal had various grounds based on the misinterpretation and or the misapplication of the development plan policies. I'm not going to talk about that because they're particular to that local authority. The second appeal had three grounds regarding the application of environmental impact assessment, and a fourth ground regarding the precautionary principle. All grounds were rejected by the High Court and the Court of Appeal. But I'll just say something about the EIA arguments. Three grounds, but they really were very closely aligned. So that the first argument was that the decision maker had to consider indirect, secondary or cumulative effects under the EIA directive, and production was one such effect. So the argument is, if you're going to give permission to somebody to look into the viability of fracking, you've got to anticipate that there's a fair chance that shale gas production is going to follow if that exploration goes well. So that was one ground. Second ground, decision maker had not complied with the duty to assess environmental effects at the earliest possible stage. So again, a point about production. And finally, decision maker had taken into account benefits of fracking without weighing against those benefits the environmental harms of production. So again, looking into the future, if the permission goes well, we're going to end up with shale gas production. Now, all those grounds were rejected, in essence, because commercial extraction would be subject to a further planning application and EIA. So all these points about you haven't assessed it were all wrong, because if it goes well, there'll have to be another planning application and another environmental statement. But some gas would be produced at the exploratory stage, and this is what Mr. Justice Dove had to say in the High Court. He said, quite apart from the fact that this complaint was not raised either prior to or during PI, there is and was no evidence to support any suggestion that the provision of gas from the site to the grid and thereby to residential or industrial users will lead to any increase in the consumption of gas and therefore the generation of greenhouse gas emissions in the UK. So the focus there was on territorial consumption of gas, which is obviously in accordance with the Climate Change Act and policy in England. And in the Court of Appeal, the Secretary of State said, made this point about transportation emissions. Domestically produced gas may in fact generate a lower level of greenhouse emissions than imported liquefied natural gas. Now, the case wouldn't have arisen in Wales because PPW 10 says no fracking. But if it had and if the logic of the coal policy had been followed, the debate would have been couched very differently. It would have been looking at emissions from gas consumption globally and so on. And the point made by the Secretary of State that you avoid those transportation emissions wouldn't have prevailed if, for example, they would have been consumed in their country of origin in any event. I'll just quickly run through this Banks case, open cast mine. The local authority wanted to grant permission. It was called in. The inspector recommended permission, and the Secretary of State accepted most of the inspector's discrete conclusions, but rejected the recommendation because of the very great weight he gave to the adverse effects of greenhouse gases. And those adverse effects are, if you dig up coal, it's going to be I think coal is going to be consumed at a power station, and there you have your emissions. Developer appealed 2 grounds. The first was to do with the interpretation of paragraph 149 of the MPPF. I won't say anything about that. And a second challenge was that the Secretary of State had wrongly taken into account the emissions which would be produced by burning the coal, and the developer was successful on both grounds. On the second ground, the argument at inquiry is set out there. So Friends of the Earth saying if you increase the supply of fossil fuel, that's going to decrease the price of coal, there's going to be more consumption and less of an incentive for people to transfer to alternatives to fossil fuels. And Banks made the point, the developer, that if this domestic coal isn't burnt, then imported coal will be burnt, and it'll have no net effect in terms of domestic emissions, save and to the extent that it'll actually be a slight improvement because you don't have the transportation costs and emissions. The Secretary of State tried to argue that, or the counsel for the Secretary of State said, well, the proper interpretation of the decision letter is that the refusal of planning permission would not necessarily lead to an equivalent amount of imported coal being burned. Barrister David Elvin accepted that previously decisions had always proceeded on the basis that domestic fossil fuels would simply replace imported fossil fuels, which, all other things being equal, is a good thing. The upshot was that that couldn't really be tallied with the decision letter. The Secretary of State's reasoning was unsupportable, so failed on both grounds, or the Secretary of State failed on both grounds, so the decision was quashed. Now, just some reflections. The focus on both of those cases was on territorial emissions rather than global emissions. If the Secretary of State had decided in the open cast mining case and stated, well, in accordance with Welsh coal policy, even if this simply replaces imported coal, that imported coal is going to be burnt somewhere else, so it's bad. And the point really, I suppose, of the Welsh coal policy is if fossil fuels remain unextracted, they can't contribute to greenhouse gas emissions. So thank you for that. I hope
thank you very much, Emyr. No, it's one of the challenges we face at the moment with online provision. In that sometimes we have satellite delay, etc., and different web strengths. But hopefully you can bear with us on this. So I'm going to, without further ado, move on to Annabel Graham-Paul. So over to you, Annabel. Thank you.
Can hear you, Annabel. Just click that microphone button for me, please.
Annabel, sorry, we still can't hear you.
Audio. Can you hear me now? Can you hear me now?
That's great.
Yeah.
Thank you.
Sorry about that. I don't know where I got to, so I'll just start again. So I'm going to be talking about climate change a bit more generally and its impact on planning. And I was thinking, if we can all take our minds back to last year, to the time before COVID, before lockdown, and if you remember 2019, it was all about climate change emergency, Extinction Rebellion protests, and it was really seen that climate change was the most pressing issue that was facing society today. Now, obviously, we have many other pressing issues now, not least fighting a global pandemic and dealing with its effect on the economy. But climate change has not gone away. And so, particularly in relation to development and planning, it's still essential to be aware of the recent case law and the international obligations, particularly with regard to net zero by 2050. So I'm going to start by, particularly because we've got such horrible weather now, a case about sunshine or sunlight. And this is the case of McLellan and Medway Council. And just in terms of the background, it was a very simple development. It was just the installation of dormer windows and an extension on a house. But the council mistakenly believed that there was no overshadowing that was going to be caused to the neighbours' solar panels. Now, the council accepted they made a mistake about that, but they sought to argue that the effect of overshadowing on the neighbour was not a material planning consideration. So the case came to the High Court before Mr. Justice Lane, and he confirmed that the mitigation of climate change is a material planning consideration, which decision makers leave out of account at their peril. He said that there was unanswerable force in the claimant's submission, that particularly given what was being said about climate change nationally in relation to new development, the council was not entitled to reject it as immaterial. And it didn't matter that the solar panels on the neighbour's house were modest in scale, that was irrelevant. And the judge also rejected the contention that the effect on the solar panels was concerned purely with a private right, so it wasn't something that was relevant to planning. So that's just on a very simple level, a small householder application, a warning that the effect on climate change is going to be a material planning consideration whenever it is engaged. One example in practice is a scheme in Bristol which went before a planning inspector. It was a scheme for 33 retirement apartments for the elderly, and the inspector dismissed the scheme on the basis that the developer had failed to demonstrate that the design and layout could adapt to climate change. In particular, the concern was about extreme weather conditions and whether the apartments were going to be able to be properly ventilated for potential hot summers, particularly with elderly people living in them. So such matters, the potential to have design that is going to be able to respond to potential changes in climate, need to be taken into account at an early stage in the process. So with that sort of general background about the importance of climate change as a material consideration and in designing schemes, I'll turn to the issue of net zero by 2050. And for anyone who's not familiar with net zero, I'm going to just run through the background as to what it is and how we got there. So a key issue in achieving the objective of stabilising greenhouse gas emissions in the atmosphere is the setting of various targets for the reduction in emissions, as measured originally in 1990. So in 2007, advanced industrial countries like the UK agreed that they would achieve emissions reductions of 25 to 40% by 2020. That was the Bali Action Plan, which was agreed at the Conference of Parties to the UNFCCC. So that's just going back to 2007, but since then the EU emissions trading scheme has committed to a reduction of at least 40% by 2030 and between 90 and 95% by 2050. We then get to 2016 and the UK signs the Paris Agreement on climate change, which aims to substantially reduce global greenhouse gas emissions in an effort to limit the global temperature increase in this century to 2 degrees Celsius above pre-industrial levels, while pursuing means to limit the increase to 1.5 degrees. So that's a little bit of the background as to where we are with the targets. Then what happened after the Paris Agreement, we have the case of Plan B Earth and the Secretary of State for Business, Energy and Industrial Strategy. And just to note, there are 2 Plan B Earth cases that I'm going to be talking about. The same claimant, different defendants. So this is, if I call it the Secretary of State for Business one, the other one is the Secretary of State for Transport. So in this case, permission to bring judicial review was refused to challenge at that time the Secretary of State's refusal to revise the 2050 carbon target under the Climate Change Act 2008. Back then, the target was for an 80% reduction as compared to 1990 levels. And Plan B Earth contended that the target must be tightened in light of the Paris Agreement. However, it was held that the setting of the target was an area in which the executive had a wide discretion, and the Secretary of State had neither frustrated the legislative purpose of the 2008 Act, nor failed to understand the advice as it then stood of the Climate Change Committee. So at that time, the courts were giving quite a wide discretion to the government in setting their targets. They weren't bound by the Paris Agreement. It was simply something that was there as an international agreement, and they were able to exercise their own discretion as to setting the targets. However, following that case, there was then published last year a report, Net Zero, the UK's contribution to stopping global warming. And that report recommended, it was a report of the Climate Change Committee, and that report recommended that the target be tightened in light of the Paris Agreement. And the government responded and amended the target in the Climate Change Act by virtue of the 2019 Climate Change Act 2008-2050 Target Amendment Order. So we now have in the Climate Change Act a 100% target in reduction in greenhouse gases from the 1990 baseline. And so that's what's meant by achieving net zero by 2050. Now, just to clarify what that means, net zero doesn't mean that the UK must aim to stop producing all greenhouse gas emissions by 2050, because obviously aviation, agriculture, some industry will inevitably have to emit some beyond that date. However, those residual emissions are required to be balanced out, for example, by carbon capture and storage and by afforestation. So that's why we are seeing in policy a large focus on planting trees and other forms, not just of reducing greenhouse gases, but compensating for those that we can't avoid still emitting after that date. So net zero must be reinforced by credible policies and decision making across government. And you may have seen the draft NDF that was recently being consulted on in August. I think it's just been laid before the Senedd, and that is going to, you know, people have been looking at that clearly in terms particularly of net zero and how it will respond to that. There's also an emphasis on a need for urgency. So climate change is not just a material consideration, but one which arguably now, perhaps more so than back in 2019, before we had this report, now one might argue it's not just a material consideration, but it's one that decision makers are justified in giving considerable weight. So that's a little bit of the background to where we are with net zero. So I'm going to come on now to some of the case law and look at how net zero has been applied by the courts. So the first case is, as I say, the second Plan B case. This is Plan B Earth against the Secretary of State for Transport. And I've just put brackets Heathrow, as that's the way to remember this one. So this was a very well publicised challenge to the Secretary of State's designation under the Planning Act 2008 of the government's Airports National Policy Statement favouring the development of a third runway at Heathrow. It was litigation which involved a number of parties, including the local authorities, Client Earth and various other action groups who opposed the expansion of Heathrow Airport. And so they were challenging the national policy statement, which set out provision for a third runway. Note here the sort of statutory hook to the challenge is that in section 5 subsection 8 of the Planning Act 2008, the Secretary of State is obliged to take into account government policy in his designation decision. So this was a Court of Appeal decision overturning the Divisional Court, and the question that was being raised was the effect of the Paris Agreement and whether the Paris Agreement should be understood to be part of government policy relating to the mitigation of and adaptation to climate change. Those are the words from the Planning Act. So the Divisional Court had held that the Paris Agreement was not relevant because it was an international agreement. It wasn't government policy, and so the Secretary of State had a discretion as to whether to take it into account, and that's very much along the lines of the earlier Plan B case. However, the Court of Appeal, in particular Lord Justice Singh, went the other way and said that the Paris Agreement was so obviously material to the designation decision that it was irrational not to have taken it into account. And so this vitiated the designation of the airport's national policy statement and also its strategic environmental assessment. And so he held that although it was an international agreement, it was in a broad context part of government policy on climate change. Note that so all work on developing the plans for the Heathrow third runway has stopped as a result of this decision. However, permission to appeal to the Supreme Court has been granted, and so that is one to watch out for, and we will see if Heathrow third runway is revived again as a result of that. So the next case is Client Earth against the Secretary of State for Business, Environment, Industry, Skills and Drax Power. This is a recent decision of the High Court. It's a challenge to the Secretary of State's decision to uphold the grant of a development consent order for the construction and operation of 2 gas-fired generating units against the recommendation of her examining panel. There are 9 grounds in this case, so it was quite an in-depth and complex case, but several of those grounds relate to greenhouse gases and net zero. So judgment was handed down in May this year. Note all of the grounds were dismissed. However, there is an appeal to the Court of Appeal which has been heard, but the judgment has, as of this morning, not been handed down, but it is I'll come on to later why. I think it is due to be handed down very soon. So everything I say may be completely superseded by that judgment. So be aware of that. As I said, this is a highly topical subject, climate change, and it's ever evolving. There's a lot going on. But the important point to note about Drax is that unlike Plan B and the Heathrow National Policy Statement issue, this is a challenge to a development control decision, in the sense it's a challenge to the grant of a DCO rather than a challenge to policy making. And note here then that all of the grounds were dismissed, and I will suggest this illustrates a critical distinction between the role of the Paris Agreement and net zero, between policy making and decision taking. So in terms of the background facts, the claimant persuaded the examining authority to revisit need, which had been settled in the relevant energy national policy statement, taking account of climate change, and argued that there was no need for this development based on up-to-date figures rather than what was in the MPS. However, the Secretary of State rejected the examining authority's approach and relied on the MPS. So said, you know, the MPS says that there is a need, therefore there is a need, never mind what the arguments were about climate change. The Climate Change Act target, nevertheless, was identified by the Secretary of State as a matter both important and relevant to the decision on whether to grant consent for the development. So some important preliminary points, just to note to set the context for the court's findings. The Planning Act 2008 makes addressing requirements of the Climate Change Act a policy-making task, so not a decision-making task, and there's a critical role of systems beyond planning control to influence types of infrastructure coming forward. Furthermore, the Planning Act prevents the use of Section 1047 as a vehicle to challenge the merits of the MPS based on net zero, and so there's a preclusive or presumptive effect of an MPS, and that depends on the wording of the policy and its proper interpretation. So in terms of the approach to need, the court rejected those grounds as a barely disguised challenge to the merits of the policy on need in the MPS. So the evidence that the claimant had adduced at the examination relating to the impact of the move to low carbon generation since 2011 could not alter the interpretation of the policy, which is a matter of law. So it's down to the government to amend the policy, not down to the decision maker to go behind the policy. So ground 3 then concerned a misinterpretation of the MPS on the assessment of greenhouse gas emissions, and the claimant alleged that the Secretary of State had disregarded greenhouse gas emissions as a material consideration. And the Secretary of State did not, it was held that the Secretary of State did not treat greenhouse gas emissions as irrelevant or something to which no weight should be given, but the policy statement made clear that greenhouse gases is not a reason for refusal in itself, and that was not legally objectionable. So it's not irrelevant, it's a material consideration, but it didn't need to be a reason for refusal in itself. So ground 4 then concerned the balancing exercise to be drawn, and it was alleged that there was an error in how the Secretary of State had carried out the balancing exercise when dealing with greenhouse gas emissions. And the court said that the MPS proceeds on the basis that there is no justification in land use planning terms for treating greenhouse gas emissions as a disbenefit, which in itself is dispositive of an application for a DCO. So the Secretary of State did consider whether the adverse effect on greenhouse gas emissions should be given greater weight in this case. The MPS did not preclude that possibility so long as greenhouse gases emissions were not treated as a freestanding reason for refusal. So again, it's material, it's weighed in the balancing exercise, but it's not a freestanding reason for refusal. So then it was argued that there was no opportunity to make submissions on the implications of adopting the net zero target. And the court held that the net zero target was important and relevant to the decision on the development consent order, but it couldn't alter the policy in the MPS. So it's going back to grounds 1 and 2. And it was not incompatible with the MPS because there are a range of potential pathways to achieving net zero. So then there was a procedural point about not having an opportunity to make submissions on this. That was also rejected, as the court found that the submissions the claimant would have made would amount to an impermissible challenge to the merits of the NPS. So it all goes back to the point that you can't challenge the policy. Then finally, similarly, we've got failure correctly to consider net zero and the Secretary of State's reliance on other mechanisms outside the planning system, such as electricity market reform, etc. That was a matter for her judgment and was consistent with the MPS. So just to conclude on DRACS, a number of grounds, but they all really come back to one thing, which is that net zero is relevant, it is important, it is a material consideration. But if you have a policy which sets out a need case for a particular development, you as the decision maker are stuck with the policy, even if you think that the policy needs to be updated in light of net zero. It's a little bit similar, I think, with some historically with some wind farm cases where objectors come to an inquiry or to a committee and say, oh, actually the turbines don't generate very much electricity, so there isn't really a need for them. But if the policy says that there's a need for them, it's not for the decision maker to look at other technical evidence and go behind the planning policy on it. So a case to watch out for, which is going through the system at the moment, is a judicial review by the Mayor of London of the Riverside DCO. This is a development consent order for an energy for waste facility, and it's opposed by the Mayor of London, including on the grounds of greenhouse gas emissions impacts. The proposed grounds are very similar to those that were pursued in DRACS. However, they were drafted before the judgment was handed down in DRACS. So this case hasn't been heard yet. I think it's due to be heard in October. And so the statement of facts and grounds recognises the need to, they may have to review those grounds once the judgment in DRACS is available. So as I said, DRACS is being appealed, so it's all going on. This has got to be heard. So they've all kind of got to come together and end up being interlinked. But that is another case to watch out for. So you've got Supreme Court in the Heathrow case, DRACS appeal judgment being handed down soon, and this judicial review, which will be heard after the DRACS Court of Appeal judgment is handed down. So some conclusions here, lots of cases going on about net zero, different approaches of the Divisional Court, the High Court and the Court of Appeal, different approaches to policy and the MPS, and how the Paris Agreement is considered relevant as government policy that needs to be taken into account in setting national policy statements, or indeed a local authority setting development plans, or Welsh Government setting national policy, but a different approach for individual decisions being made on planning applications, where you look to the policy rather than looking above the policy. So there are significant obstacles to making the effect on greenhouse gas emissions a reason for refusal in itself in fossil fuel cases or in any other cases, but it is going to be very relevant to policy going forward. So I think we're nearly running out of time, but that is the end of my talk. But please do, I think we're going to hand back to Roisin now. Do submit any questions, or if you think of anything at a later date, do get in touch with either me or with Emyr. And we'll be very happy to answer them. Thank you.
Annabel, and thank you everyone for bearing with us. There are sound issues. West Wales, there's obviously a satellite issue or something along those lines, but that was excellent. Thank you very much, Annabel. If anyone's got any questions, we do have a couple of minutes. We haven't got any yet. You've probably been bombarded with lots of information and data on that, so please do submit them in the last couple of minutes. I think if Emyr, you want to join us as well, the webcam. I think something that Emyr and Annabel have demonstrated is the complex decision making in all of this, about how, not necessarily just in planning, but how you make decisions on use of coal, for example. And Emyr, you described it very well about where is the coal coming from. We need steel production to support other sustainable activities such as railways. We want people to travel by rail if it's longer distance, so we need steel for that. So how do we manufacture the steel? So there are lots of wider issues, and I think you've demonstrated very clearly that it is very complex, not just in the planning considerations on that factor. And Annabel, you've focused really on the as well, demonstrating the importance of the policy wording, and that we need to really focus on that, and that the policies coming out really emphasise and strengthen that climate action perspective. So we do have one question from Andrew Farrow, and this is directed at Emyr. Does the coal policy say anything about reworking of coal tips and or the pre-extraction of coal to facilitate a development site coming forward? If I hand over to Emyr. We need your mic on first, Emyr, sorry.
Yeah, it doesn't say anything about facilitating a development site coming forward. It does, however, emphasise, I think the phrase is a just transition, so that although we want to get away from coal extraction, we want to maintain and, if possible, enhance prosperity. So I think you could shoehorn a development site into that, but it would have to be wholly exceptional. And I think it talks about making coal working safe. So if you need to extract more coal in order to make the site safe, then that would be permissible, or that would be wholly exceptional. And also scientific reasons would also, are the two examples given of what is wholly exceptional. But there is that commitment to prosperity, so I suppose you might be able to argue that that brings it within wholly exceptional. It's probably a bit of a struggle, but and of course that would only be your argument to the Welsh Government wearing its hat as the body approving a coal licence. So you'd still need to get through the planning, and effectively it's identical in its content to the PPW10.
Thank you, Emyr. We have no other questions, but Annabel, did you want to add to that?
His topic, and he's answered it.
That's fine. Thank you. Thank you very much, Annabel. Okay, we'll bring this to a close. Could I thank Emyr and Annabel? I think you've really grabbed onto some really important issues that we need to think about, both in the planning process and in the wider process of dealing with climate action through legal standings as well. So thank you very much for that. Thank you everyone for joining us today, and thank you to our sponsors, Francis Taylor Building and Savills. That's really important to have that support. If anyone's missed any of the sessions which are taking place this week, you can catch up on the RTPI's YouTube channel. They'll all be available on there. And we have 2 more sessions tomorrow, one looking at climate action in other parts of the UK, as well as hearing from Jen Heal on the Design Commission for Wales. And in the afternoon, we're going to hear from young planners as well. So that isn't a young planner session, it's about hearing from future generations about their perspectives of planning and climate change. So thank you all very much for joining us, and look forward to seeing you again soon. Thank you.